get started for our final presentation. And during this final presentation, I want you to think carefully about where property rights begin and where they end, and when they're secure and not so secure, and what the outcomes are when they are really secure compared to when they're not so secure. As we're thinking about solutions, I want you to think about where we are now and how we can get to somewhere else. And I also want you to keep in mind what's realistic, what really happens, how people really behave, versus what is sort of idealistic and theoretical and how we would like to see people behave, right? What is really going to happen, and compared to what, right? Our solutions may not be perfect. There are all sorts of different types of solutions we can think of, but to think of realistic solutions, we want to start from where we are and think about what are the other options that exist out there, and is this the best step for us to take? I also want you to think about those certain characteristics that we've talked about of property rights, my deal of property rights, because those characteristics are really important for markets to function well. And if we want markets to function well to help us protect the environment, then we need to have that secure bundle of sticks. If we don't have that secure bundle of sticks, we can then think about how we're going to get about handling the missing sticks in that bundle. And it might take some sort of outside intervention to help us get there, to help us define what those are. Because when I say this, oh, all we need is secure property rights, I'm not trying to say, well, it's a simple answer. I'm just trying to say this: if we have problems, this is a really good place for us to start looking at what those problems are and to try to come up with some solutions, thinking about the basis here. We can't exclude people, for example. We talked about the fisheries. So how do we resolve that issue? It really helps us get to the meat of the problem right off to the bat. But again, it's not to say those are easy problems to solve, especially if we're talking about air pollution, non-point air pollution, non-point source water pollution, some great questions that you guys have had in that regard. Those are some of the really hard problems to solve. And here in the United States and in most developed countries, the environmental problems that we have left to solve are really tough ones, right? We've solved the easy ones. If you're looking at the developing world, there might be some easier, more property rights based, and I say that easier with a grain of salt, because creating those property rights and defining and securing those property rights is not easy, right? We might know why we have the problems, but it's not easy to go in and actually create better property rights, but it is a place to start. So we have one more presentation left that's going to help us think even deeper about this, and we're going to consider how constitutions might help us protect environmental rights and protect our property rights. So we have with us this afternoon Eric Alston. He is a research associate with the Comparative Constitutions Project, which is affiliated with the University of Chicago Law School. He has many other hats as well, but that's the hat he's going to wear right now. Thanks for joining us, Eric.
So before I dive in, I want to tell you all a little bit about myself, but also situate Holly's comments in a somewhat broader context. So how many of you have lived with roommates? How many of you have chosen your roommates? So presumably when you choose your roommates, you choose people you like, that there's characteristics you like about them, so on and so forth. Does that mean you never got into a disagreement with your roommates? So I struggle to find a single person who says they chose their roommates, chose people they liked, but nonetheless, when you live in close contact with someone, disputes emerge. Disputes emerge in a family. Disputes emerge in sort of every voluntary associational form that we see. So property rights are, in my mind, one of the most fundamental institutional forms societies have developed to deal with disputes. If you go back early in history, the earliest recorded records of rule sets include treatment of property. If you want to look at the Ten Commandments, there's several that directly reference property of others, as well as what you should and shouldn't do in response to that property. It's not just Christian traditions, though. So to me, that indicates there is something fundamental about the nature of property, that in order to provide orderly systems of human governance, whether you opt into a system or whether you're just born into one, these institutions, property rights as institutions, are fundamental for providing ordering of human systems. It's what interests me in them. I would say if you could lump my research into one category, it would be what's increasingly called institutional and organizational analysis. So the rules that human societies develop to resolve disputes, but ideally to prevent disputes and to facilitate voluntary interactions and transactions among individuals in that particular group. To me, that's institutions and norms. And I'm actually working on a textbook forthcoming next year on Cambridge that's entitled just that, Institutional and Organizational Analysis, Concepts and Applications. Because I think these questions are fundamental to human order. During my time at the Chicago Law School and subsequently, all of my professional experience was advising constitutional reform processes. So sometimes it was process design, like in South Sudan, trying to understand where different ethnic groups had moved as a result of the years of conflict there, so that you could design an educational process about the importance of a new constitution for that country. Sometimes it was directly advising the drafters themselves, either responding to questions they had, looking over their draft, this was in Somalia and Yemen, or preparing educational materials regarding decentralization for Libya's drafters. Basically all based in a belief that our systems of governance are fundamental. You ask an anarcho-capitalist, and I have nothing against anarcho-capitalists whatsoever, but I feel like sometimes they miss the ball in terms of, okay, let's say we were to voluntarily associate instead of the nation states that we currently see. I think we would see the emergence of a lot of the same institutions we have today. The enforcement might vary slightly, but contracts are sort of the bedrock of arguments for an anarcho-capitalist society, voluntary contracts. But what happens if someone doesn't complete their end of the bargain? Would that never happen in a purely voluntary society? Some people say it might happen less, but I think it would be missing the ball entirely to think that contracts wouldn't break down in these societies, because that would imply no risks are taken, no intervening natural events would occur, and none of the human condition would enter into it. People get sick, mistakes happen, things come up, acts of God. There's actually provisions in a lot of contracts and law dealing with acts of God, the unforeseeable circumstance that prevented me from completing my end of the bargain. So whether or not, regardless of your view of this is the right system of government, to me, these questions are fundamental. First, property, your own property, the fruits of your labor, what you can do with it, what you can convince others to give you, which is, to me, property is almost inextricable from contracts for that very reason. What good improvements to your home if you can never sell it? I mean, there are benefits that you might derive if you're like, I'm going to live here for the rest of my life, but the nature of property in modern developed economies relies on your ability to transact successfully with it. So to me, my interest in constitutions was based in a belief that having a fundamental rule set that sort of is the backdrop within which all other rules in a society emerge, both formal but also informal rules, norms of behavior, custom, as well as the actions that you take in a de facto sense to enforce your own property or to ensure that contracts you've entered into are completed. These are all just part of the web of institutions that basically make up the lifeblood of modern developed economies. And to me, constitutionalism is an important prerequisite to the level of development we've seen today. So I've worked in a variety of contexts, many of them very, very frustrating, in terms of trying to enact a measure more of restraint on the government, a set of rules that everyone will abide by, that will be applied to everyone equally and impersonally. But it's also a mistake to think of the rule of law as a binary. Because does that mean we have the rule of law? Compared to many, many nations, we enjoy so much more of the rule of law than they do. But to say that it's binary, that we have the rule of law and they don't, is making, in my mind, a fundamental mistake, which is rights are violated here. That's why we have redress in the courts. When people violate your property rights, you don't have to self-enforce. So it's it's a mistake to think, oh, we have more rule of law than other countries, ergo, we have the rule of law. It's always going to be a relative measure because contracts break down, rights infringements occur, and certainly in some cases you can point to, I did a lot of work with the Exoneration Project as well, trying to free people from prison who I believed were innocent. I believe their rights were fundamentally infringed by police actors. So, in effect, these questions cut to the very core of the ordering of human societies. So I'm going to start by basically introducing a case study of Ecuador, because we're talking largely about environmental questions here, natural resource management questions, which increasingly are some of the most important and contentious issues, not only in our society, but as I'm about to show you, in Ecuador's society as well. So I'll spend some time stepping you through Ecuador's most recent constitution, then I'll try to bring it back to the general, talking about the policy responses we have on one dimension, being how do we define rules? It's largely situated in the notion of property rules, but as you deal with environmental questions, especially in our country, if I didn't mention regulation, I would be deeply remiss. So that's policy responses, whether they're predictive, reactive, or contractual, or underpinned by private order. But then there's another as fundamental question, which is, what is the appropriate level of governance if we want a formal rule enforced by a third-party actor? Where should we situate that? So I entitled that little section, "A Bill Goes to Washington, Helena, or Bozeman." These are all three different units of governmental ordering that have different advantages and disadvantages associated with them. Then I'll give a brief review of where things stand currently in the US West regarding especially that question of decentralization and federalism, introduce some notions from a Nobel laureate, Elinor Ostrom, and then finally end with a conclusion that I hope at least challenges you. So, Ecuador in 2000 had a poverty headcount ratio 64.4%. It's pretty high. 2015, 22.5%. So one, I just want to situate the country with you in some of these development indicators so you can understand the transition that that country has been going through. And I'm very non-normative from the perspective of, oh, they did right or they did wrong. I'm going to point out a fundamental tension that exists in their constitution between environmental rights guarantees and other progressive positive rights guarantees. Similarly, their inequality decreased significantly from 2006 to 2014. 2006 being the year Correa came to power, 2008 being the year he enacted a new constitution with his party, Alianza País. In 2015, their per capita income was $6,000, so still quite poor by US standards. And I should note, it's among the 17 most biodiverse countries in the world, despite being much smaller than other countries that are ranked that high. And this has relevance to some of the subsequent points I'm going to make. So here's a picture of Correa and his party, Alianza País. They represented the broad disillusionment with the government during the prior decade. Might want to use a clicker. Up to 80% of the population felt excluded from the political process in the decade prior. And that's taken from several citations. I have an article on this that's under submission at a journal called Constitutional Studies out of UW-Madison. But if you feel like that's a speculative number, well, the referendum for a new constitution, whether or not they needed a new constitution for the country, passed with 82% of the vote. That's a stunning referendum. So to me, that's a more difficult number to argue with. The Constitution passed with a 62% of the vote. But to me, the indication of 82% of the population demanding a new Constitution, that does indicate a level of at least perception of a breakdown in governance institutions. And in the decade prior, you had 7 different regimes in the country. Each fell under different circumstances, but each was linked to corruption. So there was definitely, it was inarguable that there was a perception that the institutions of governance were inadequate, were not working for the country. So effectively, the rhetoric that Correa used was, I am counter-hegemonical, the hegemony being the prior neoliberal elites who govern the country, by all accounts, quite poorly. They had a collapse of their currency during this prior period. Whether or not you think this was the right answer to the problems that came prior, certainly there were problems with the prior regimes when many of them couldn't hold on for even a single year. You also see him saying we are post-neoliberal, and absolutely the constitution that they enacted was the antithesis of neoliberalism. Whether or not the prior regimes were actually neoliberal in a free market sense, or whether they were very crony capitalist or fundamentally autocratic, is a separate debate that I'm leaving aside. I'm not here to critique neoliberalism or nominal neoliberalism, as I like to think of it, as it typically occurs in Latin America. Effectively, the population saw the prior regimes as linked to neoliberalism, at least in name, and they wanted something different. That's what they got under this new constitution. Whether or not the new constitution is doing what it actually says is a question I am going to explore at length with you. So again, Correa sees himself as the leader of this new Latin American left. So one of the most notable aspects of their constitution was their environmental rights, which were tightly tied to notions of indigenous rights. There's a wide variety of indigenous groups in Ecuador, and they were among those who felt significantly disenfranchised under the prior regime. So they played a large role in the rise of Alianza País, and the lip service at a minimum that Alianza País paid to the indigenous groups, as well as to the environmental interests, was significant. And that led to 82% referendum for a new constitution, but I want you to think about that other number. 62% voted for its passage. So you see a significant fall from we want something new, we need a new form of governance, and what came out of the Constitutional Assembly. There were a lot of compromises wrought, such as recognition of indigenous languages without adopting them as official languages. Guarantees to the right to benefit from the environment, which was in tension with all of these other rights. These rights definitely encapsulate a very broad notion of what's called Pachamama, Mother Earth, where the well-being of humans is inextricable from that of the environment. This is fundamental to the indigenous beliefs of those in Ecuador. Another innovation is that the guarantees to environmental well-being are not tied to individual property ownership. Typically, you have actionability in many countries for damages to your property. If somebody damages in a fundamental way even the ecology of your property and you value it in a certain way, that can proceed under tort or property law depending on the country. Here, in theory, they made these rights actionable whether or not it was your property that was affected by environmental degradation due to the actions of others. They include rights to life for every organism within the country, as well as rights to restoration from natural resource extraction, rights to clean water, rights to consultation for affected communities by any natural resource extraction project. I'll get into it in a bit, why they were so specific on some of these fronts, and why it's understandable that you saw this outcome, whether or not this outcome has actually resulted in what they want. And immediately, you see sort of a breathless wave of applause from a number of progressive legal scholars and commentators worldwide, basically saying, this is the new model. This is the new constitutional model for environmental and indigenous protection. I say, let's see what happened. In theory, anyone can bring claims under these rights, but it's less clear in practice. So another indigenous notion that's encapsulated in the Constitution and was adopted by Alianza País under Correa during his first 2 terms was summa causa, which, a picture that I got from Google, basically, this is showing sort of this harmonious farming, probably subsistence farming with, the earth being this rich natural space. But I want to note There is industry in this picture, and that's why I chose it. You've got a windmill, you've got parcelized farms, you've got a variety of agricultural activity, as well as some tourism. But you ultimately see two competing definitions of this term emerge. The indigenous groups say individuals' well-being is linked to environmental well-being. Absent environmental well-being, you are not achieving summa causa. You do not have this good life. So for the indigenous rights groups that increasingly came into opposition with the very party that they helped bring to power, for them, increases in living standards that result in environmental degradation are in conflict with summa causa. For Alianza País, summa causa is a balancing act. Yes, the environment is important, but so are increases in material well-being. Remember how much the poverty headcount ratio fell after the inception of Alianza País. They argue you have to have some measure of environmental guarantees, but increases in material well-being are a fundamental component of this notion of the good life. And this is enshrined directly in the development plans of government agencies under the Alianza País regime. And so this is a picture of Correa that I think illustrates this tension. You've got him, his security guards, several other probably important politicos wearing very sharp suits, surrounded by very traditional indigenous garb. And so he was engaged very much in a balancing act, trying to prioritize some of the indigenous demands, some of the environmental demands, with a larger group of the populace that argued for more traditional positive rights in the Constitution. The right to health care, the right to education, the right to benefit from the natural wealth of their country. So not everyone in the country is just, a raging environmentalist or believes that indigenous rights should trump all others. Many people just felt like under the prior regimes, they were not seeing the benefits of the large-scale natural resource extraction that was occurring in the country. So under the new Constitution, you see a significant amount of economic restructuring. 2000 debt meant, wow, we need money to implement a new government under a new constitution. So they immediately sign a forward contract with China for oil revenues over 40 years. They nationalize a lot of the natural resource extraction directly. 71% of oil production in 2011 was by the state. How important is natural resource extraction to the government? Arguably, it's fundamental. 50 to 60% of export earnings are from the oil sector alone, and 30 to 40% of government revenues come just from oil. It's hard to find many other countries where you have that level of dependence on natural resource extraction. I'm not here to make a normative argument about whether or not Ecuador should be engaging in natural resource extraction. I would argue that in order for them to reduce poverty in the country, in order for them to actually provide increases in material well-being, especially given the positive rights that they guarantee to healthcare and education, and the anticipation of the citizenry that the government would be providing those things, they had to keep going with natural resource extraction. To me, this was an unavoidable outcome if they wanted to see decreases in poverty. They wanted to see economic development. They're fundamentally wedded to their natural wealth, and they recognize this explicitly in the Constitution. You see pretty significant economic growth during most years of the regime until 2016, and you've also got a negative in 2017 predicted. Why? Because oil prices, commodity price volatility, means when you're dependent, when 30 to 40% of your government revenues are coming from oil revenues, if you have a commodities price shock, if you have a glut the market is currently seeing, I think I saw an article in the Wall Street Journal this morning about that question, then suddenly your revenue source goes away in comparison. Nonetheless, given these outlays, given infrastructure development that was occurring largely because of major government projects, especially natural resource extraction projects, you see the poverty rate fall significantly from 49% in 2002 to 32% in 2011. Extreme poverty falls over the same period, but the government is engaged in this balancing act where there's this fundamental belief that our country, our people, especially our government, should benefit due to any natural resource extraction project. So a proposed gold mining project by a Canadian company, they eventually walked from it because of the amount of taxes that the government wanted to take from it. So this increasingly leads towards this tendency for nationalization or tightly defined public-private partnerships in natural resource extraction. So you've got these much lauded environmental rights guarantees. People saying this is the new template for environmental protection in a constitution. What happens? The government passes a mining law saying we have to redefine how natural resource extraction will occur in our country. And again, it puts the government front and center, the national government I should note, as either the one that's doing the extraction or the one that's in a tight relationship with the companies doing the extraction. State control of oil fields and refineries, freedom for businesses to liberally prospect for mineral substances. Unsurprisingly, given the environmental and indigenous groups and their concerns that led to the new Constitution, this met with protests before and after the enactment of the law, and subsequently it's challenged in court. What happens though? The Constitutional Court rules that the executive can declare projects in the public interest and exempt them from the environmental rights provisions. Seems odd. Seems a little at odds with the notion of what a right is. Aren't rights inviolable, or are they non-hierarchical? Are they? I thought they were absolute. This also indicates, this whole story indicates some of the tensions that positive rights, as opposed to negative rights, create. Because they create an affirmative obligation on the government to provide something. Anytime you have that affirmative obligation on the government, whether it's to provide measures of environmental protection, whether it's to provide health care, whether it's to provide education, that means money. That means a revenue source required for the government to provide that thing. This is one of the main arguments that legal scholars that are opposed to positive rights, or even scholars that just don't think they're immediately a panacea to a country's problems, point to. Unlike negative rights that say your freedoms in this sense will not be abridged, and you have an actionable claim in the instance that they are, whether it's a private actor that abridges those rights or a public actor, positive rights require affirmative action by the government. Not affirmative action in the sense that we consider it here as a policy question regarding admissions to college, but the government has to do something. So to me, this is immediately a pretty problematic outcome from the perspective of constitutionalism. So what do the rights of nature actually look like in court? So a different group of scholars actually went down there and on the ground examined cases in which the rights of nature emerged. 13 that they identified. Isn't a very large number given the level of natural resource extraction. 10 out of those 13 were successful. So this pair of progressive scholars say the rights of nature are successful in Ecuador. This is a new model. I have some doubts. 7 out of 10, those 10 successful claims, had a claimant that was a government official or ministry. And these claims prevailed against 3 classes of defendants. Remember, the backdrop to this is the executive branch of the national government. Any major natural resource extraction project it's engaged in, it can wave its hands and say public interest, environmental rights do not apply here. So to me, these outcomes are unsurprising given that backdrop, which is private individuals, private companies, and local governments are being held accountable by the national government for violating the rights of nature. But wait, who is the most likely violator of the rights of nature provisions? The national government. They're the ones engaged in the major resource extraction projects. They're the ones whose revenues are fundamentally dependent on those major resource extraction projects to provide goods and services that the majority of the population is demanding. And so I don't think I use it in this presentation, but I call this a political economy of rights implementation. Those rights which are most popularly demanded, the rights to healthcare, the rights to education, the right to materially benefit from the country's wealth, largely derived from natural resources, those rights are being provided, but at a cost to other rights, at a cost to the widely lauded rights of nature. The only successful individual claimants were foreign landowners who suffered property damage from a local infrastructure project. A municipality was building a new road. It changed the course of a river. That river ended up flooding a significant portion of their land, so they made a claim under the rights of nature. Absent the rights of nature, would such a claim proceed here in the United States? Absolutely. Damage to your property by a government action as a result of their construction project? Sounds like a pretty property law 101. So to me, I feel like this could have proceeded under ordinary tort or property law. So my argument, my thesis in this research project is that the rights of nature function more like a regulatory mandate than a rigid constitutional assurance. And if I have time, I'll go into other areas where this is effectively, I argue, is weakening the constitutional order writ large. Because the rule of law depends fundamentally on the belief of the citizens governed by a particular constitution, in the legitimacy of that constitution, in the belief that both powerful private actors and powerful public actors will be held accountable in a relatively systematic way. And to see the executive be able to exempt themselves wholesale from a large suite of rights in the Constitution, I argue this has led to other rights deficiencies on a larger scale. But there's an additional problem. Nationalizing industries, the dispute with Texaco and Chevron, and every scholar that I found that looked at this particular instance, this was in the Oriente region of Ecuador, oil extraction by Texaco, which is now named Chevron. You see major environmental degradation based upon oil extraction in this region over decades. I mean, to where in documented ways, the health of different communities surrounding these projects were affected. So it wasn't just the right to life of certain organisms, it was actually individuals whose health was significantly detrimentally affected by this project. Regardless of the person's ideological stance, it was almost unanimous that this was happening. You see court victories within Ecuador. Under the new constitution, though, after the government has nationalized all foreign resource extraction companies. So you have 2011 and 2013 court victories. The Constitutional Court ended up taking it up. They downgraded the damages to $9.5 billion. That might be a bit of a political statement as opposed to an assessment of the true damages, but no one I know who was looking at this question said there wasn't massive, massive damages. But what's the problem? Texaco or Chevron has no property in the country against which to assess these damages. So Texaco, Chevron says, okay, yeah, we ignore the judgment of your court. You took a lot of our property, and no thank you. We refuse to pay. Ecuador then sues Chevron in the US courts and loses. So to me, there's a hidden cost to nationalization of industries, which is who do you hold accountable for bad acts, especially prior bad acts? You can't haul them into court, and Is the national government going to haul itself into court and levy an assessment against itself and say, we committed a bad act and we are responsible? Or how lucky are individuals in the United States when they try to bring the federal government into court? It's pretty rare that you see a successful judgment against our government. So the court system is not particularly good at attacking the executive branch, even in our country, which enjoys a significantly larger measure of the rule of law than Ecuador. So before I get to general lessons, I also want to talk about one other proposed project. This was innovative, was again widely lauded. This was actually announced in 2007 that they had discovered in the Yasuni National Park one of the largest oil deposits yet discovered in Ecuador. This is in the Amazon region of the country, one of the most biodiverse regions and one of the most biodiverse countries in the world. President Correa says, hey, we recognize that there would be value to us not taking this oil out of the earth. But this discovery comprised 20% of the country's proven reserves. It's massive. So they propose in what was called the Yasuni ITT project. ITT was the specific region within the Yasuni National Park where the oil reserves were found. They said, international community, we're constantly hearing you trumpet about the importance of biodiversity, the negative effects of deforestation. We often get, flack anytime we're engaging in one of these projects. So international community, why don't you put your money where your mouth is? If you donate to a fund half the value of these reserves, we'll keep it in the ground. By 2016, I think they had maybe 3% of the amount they were asking for, and only 1% had actually been deposited. The rest was just promises that it would occur at some future date. So in fall of 2016, they began drilling. One, it emphasizes the difficulties surrounding international coordination regarding environmental objectives, especially when it comes with an underlying price tag. To me, though, there is an interesting just kind of policy objective there, which was 2007 prices look very different than 2017 oil prices. So Ecuador was trying to write a futures contract to not extract its oil, but lock in a 2007 price that was quite high. Interesting institutional innovation that proved to completely fail in this instance. But nonetheless, it shows the difficulties as well as the underlying demand that despite protests within the country regarding them moving forward with drilling into these reserves, they did so. The government needed revenues, and enough people obviously supported the rest of the government's program, very, very traditionally progressive in terms of positive rights to healthcare, education, infrastructure development, all of which creates a good amount of employment as well. And to me, I'm not arguing that they have been successful at reducing poverty levels, certainly far more so than the nominally neoliberal regimes that came prior. Whether or not this is the most effective way to go about it, to me, is a larger question, not one I'm approaching here. To me, I'm interested in this tension between the positive environmental rights guarantees and how to finance the rest of the program of government, which, given other positive rights guarantees, was very costly. So I think there's a number of important lessons to consider from this study. Just as institutions matter for economic development, the field of new institutional economics, which is now being called institutional and organizational economics, effectively emerged as a critique to neoclassical models. Basically, they're saying, hey guys, institutions matter for economic development. It's not just capital and labor allocations that create a magical economic development outcome. Property rights matter, the structure of property rights matter, your political system. All of these have significant implications for economic development outcomes. That's me shorthanding a lot of very amazing scholars in institutions generally. But I feel like there's a counterpoint which is important to consider, which is economic realities within a given country create and constrain institutional change. Their need to obtain government revenues through natural resource extraction directly constrain the level of environmental protection they could actually provide. Whether they made it in terms of rights, or if they just had it going through the Ministerio del Ambiente, either way, there was a level of environmental degradation that was almost guaranteed to occur simply because they were promising a certain amount of government outlays each year. If you want to think in our own country, this is why I have Trump question mark, what about those who feel economically disenfranchised, either from globalization, which is Trump's argument? I tend to believe it's more due to automation. We're producing a heck of a lot more with a tiny fraction of the number of workers we were previously. Regardless of the underlying cause of significant amounts of unemployment in formerly robust manufacturing states in our country, those states were instrumental in the rise of Trump. And so to me, it's something of a, there's a generalizable lesson there, which is those who are economically disenfranchised in current or immediately prior periods, they have a political voice, especially in our country, which enjoys a measure more of sort of actual democratic outcomes than, say, Ecuador or other countries. So economic realities can create and constrain institutional change. And I think we're living through a period of that in our country currently. The second one is kind of my answer to the breathless round of applause that came from legal scholars for these environmental rights that we'd never seen before. Yeah, we'd never seen them before in theory, now we've got them in theory. I would argue we don't have them on the ground. So a belief that policies will just function as intended, if we enshrine a right, it will be protected, it's at least naive, if not dangerous. And this is underlying this tension between legal formalism or legal positivism versus legal realism or law and economics. There's definitely two camps in legal theory. One which says, how is this policy likely to function in practice? What is the reasonably anticipatable outcome, it's a tough word, from this policy? Others assume if we legislate it, it will be so. If we regulate it, it will be so. I'd point them to the drug war in our country at least as a modicum of a counterexample. Similarly, a top-down mandate for environmental protection requires a belief in the ability of the government to self-regulate and self-correct. This is even more the case, so this is why Ecuador is a hyper example of this, in that they are the primary resource extractor. So what is your aggregate level of faith in the ability of the government to self-regulate and self-correct itself? Our nation's founders sure didn't have a ton of faith in that. That's why they were so interested in small c constitutionalism. Checks and balances, constraint on government. Because they didn't think, especially given their experience under the English colonial regime, that the government was very good at this type of behavior. So this type of top-down mandate requires a belief in the ability of the government to self-regulate and self-correct. A question I would pose to you that will become relevant in my subsequent slides is, this might be really hard when the government is the primary resource extractor. Is it any easier when the government is the primary landholder? How easily held accountable is the federal government for its ownership of federal lands in the United States? Whether or not the environmental mandates to which it is beholden are enshrined at the level of constitutionality or simply regulation or legislation, it's still a valid question. And similarly, this is the Chevron Texaco example. Nationalization of industries because of prior bad acts may make justice for those bad acts much more difficult to achieve. And so there's both this past-looking thing, which is the effects of natural resource extraction activities sometimes aren't truly understood for decades. And so sweeping changes in the regime that governs these types of activities may have unintended consequences in terms of your ability to hold those private actors accountable. But it also has a forward-looking component, which comes back to here, which is, if you nationalize, can you hold the government accountable in future periods for similar bad acts?